Mentioned, I'm currently working on a book in which I explore the responsibility that child soldiers might bear for their acts of violence committed in armed conflict. And it also explores how societies ought to deal with these child soldiers as they return home, particularly as the societies try to transition. Okay, particularly as these societies attempt to transition from a state of war to one of peace and order. The types of societies that I am particularly interested in are those from which the child soldiers originate and to which they return, being the same societies that are the ones most victimized by the conflict. So for examples of such societies, we can look to northern Uganda, to Sierra Leone, to Rwanda, to parts of Colombia, where the battlefields usually include the same regions as either the homes of the supporters of some of the armed groups, or in cases where the child soldiers are abducted, the base of recruitment. So when the child soldiers then return home, they return to people that have borne the brunt of the violence. And child soldiers, victims, and perpetrators are then living side by side. Now, I became interested in child soldiers when I was doing research for my Ph.D. dissertation and my first book. And my research took me to northern Uganda, where, as you probably know, there was a long conflict that was being fought. And it was fought primarily by young people, or by people that had begun as child soldiers under the age of 18, and who had then grown up with this rebel group, the Lord's Resistance Army. In my first work, I highlighted some of the distinctions between different types of perpetrators of mass atrocity. And although I was well aware of the existence of child soldiers and their involvement in atrocity, and their commission of some of the types of actions that international criminal law would generally be interested in, I ignored them. And I ignored them because I really didn't know how to situate them. I didn't know how to evaluate their actions or their responsibility. And I didn't know how they ought to be dealt with by the transitional societies or by the international community. So think about it for a moment. Should they be welcomed home like any other victim? Or should they be prosecuted to the greatest extent of national or international law, recognizing that the types of actions that they commit constitute war crimes or crimes against humanity? Or should they be treated as incapable of agency? So should any person under the age of 18 be regarded as a small child who is incapable of making decisions about what's right or wrong, or making really serious decisions? Or should they be treated not as children at all, as was argued about some of the youth who were held in Guantanamo Bay as terrorists by the US? Now, northern Uganda is a perfect case in which to examine some of these questions of transitional justice and child soldier perpetrators of atrocity. And this is because they're currently exploring some of the potential transitional justice mechanisms that can be used to address a legacy of human rights abuses that happened during the conflict. And it's also because they have a great number of former child soldiers and former adult LRA soldiers that have come back to the community. And they need to be integrated successfully because they are the future of this society. Between 1986 and about 2006, 2008, Joseph Kony and his Lord's Resistance Army, the LRA, terrorized northern Uganda, abducting up to 60,000 children, who then went on to commit terrible atrocities against the civilian population of northern Uganda and other regions in the area. And some of these atrocities included murder, horrific mutilations, rapes, burning down of homes. And also some of these abductees were forced to kill or to harm family members or other members of their village before they were even taken into the bush by the LRA. And the reason behind this was to create this division, to sever ties between this young person and the community, so that community members would be angry at this person for committing this awful act, and so that this young person felt like they had no home to return to. Now, the phenomenon of child soldiering is a really difficult issue, as you can imagine. It calls into question a lot of things, like to what extent children, any person under the age of 18, can be deemed responsible for their actions, or whether young people can ever have the mental capacity to truly intend and therefore be guilty of atrocity crimes. It calls into question to what extent coercion can either be a justification or a mitigating factor, either excusing wrongdoing or making it less bad. And it calls into question the influence of war, the influence of being in the middle of an environment where the norms and expectations and morality are very different than they would be elsewhere. In some ways, the international community has rallied behind this non-responsible child narrative, seeing them not only as victims, seeing them not only as victims, but as only victims, for excusing them of any atrocity that they might commit. Now, this doesn't seem to be necessarily wholly correct, and it might actually do a disservice to child soldiers and to their ability to reintegrate into their community. And it might be dangerous to a society's plan to transition and to rebuild. So first I want to look at the general field of transitional justice. So what is transitional justice? What does it mean? What are some of the principal questions and goals of transitional justice? And we're going to look at some of the options available within the realm of transitional justice. But I'm going to look at some of them as they relate to northern Uganda. And then we're going to turn back to how we might view child soldiers through the lens of transitional justice. So what is transitional justice? Well, transitional justice is not a particular system of justice. It's not a particular institution or a mechanism. Rather, it's a strategy. It's a way of thinking about the pursuit of justice after atrocity, the way a country might deal with a significant legacy of human rights violations. It's a range of options from which the community or the international community that is involved in this transition can pick from. What are the principal questions? Well, in the aftermath of mass human rights violations, transitional justice aims to answer what can be done to help heal the wounds suffered by victims of these abuses. How can citizens be helped to close the door on a past hurt in a way that is healthy and will allow them to live happy and productive lives? What should be done so that victims feel that they are respected and not neglected, so that they feel that the crimes committed against them are not condoned, and that these same crimes are not likely to happen again? And how can social reconstruction, trust in society and its laws, and trust in fellow citizens be achieved, especially when these fellow citizens are the same ones that hurt you or your family members or your neighbors? So how can the peaceful coexistence of individuals be realized after the occurrence of mass violations of human rights? Transitional justice, then, is important for both moral and practical reasons. Morally, it's the right thing to do for the victims, and practically, not properly addressing these past abuses can relapse into violence and disorder and abuse. So transitional justice is justice that aims in social reconstruction, helping a society move to the other side of justice, from the other side of atrocity to a society that is healthy and just and peaceful and functioning. So how can this be done? Well, as I said, there are a number of different options available. We're only going to look at a few of them as they relate to northern Uganda. But generally, when we think of the options available under transitional justice, they can be divided into three categories, based each on a slightly different premise. The first category is something called retributive justice. And retributive justice generally refers to the criminal justice system. So it's the judging and punishing of offenders. And then we have restorative justice. And restorative justice is less interested in judging and punishing offenders. Rather, restorative justice is a means of restoring relationships between people, between groups of people. So restorative justice is interested in trying to meet the needs of victims and of trying to restore relationships between victims and perpetrators and other members within the community. And then finally, we have reparative justice. And I'm not going to be speaking much about reparative justice at all today, just to let you know that it does exist as kind of the third category when we're talking about transitional justice. Reparative justice really just refers to compensation. So it's a transference of resources or money to victims as a way to kind of counteract the harms that they suffered. Now, although I'm not going to talk about reparative justice, I do want to unpack some of these options available under retributive justice and restorative justice. And as I said, I'll do this by linking it to what's happening in northern Uganda. So first, as I said, retributive justice refers to criminal justice systems, basically. And for post-atrocity contexts, there are different options that might be considered for the job of prosecuting perpetrators. One of the most natural options is the domestic legal system, the legal system of the country where the crimes had taken place. Usually, when a crime is committed, the perpetrator is judged and punished by the country in which the crime took place. If you leave here today and kill your neighbor, the Canadian penal system is going to address your wrongdoing. This, of course, is an option available to countries that have dealt with or gone through these terrible atrocities. For example, in the aftermath of the Rwandan genocide in 1994, Rwanda set about trying to prosecute all of those suspected perpetrators that had been involved in the atrocity at the time. And there's something really important about that. There's something really good about local prosecutions, because it signalizes local ownership of the process. And people argue that local ownership is really important. It's really important that the victims of these atrocities are part of the response to what happened to them. But there are also some negative aspects that are inherent in domestic prosecutions after atrocity. And I'm only going to mention one of them at this point, and the Rwandan example is a really good one. Because obviously in mass atrocities, there are often so many perpetrators. In Rwanda, after the genocide, there were over 100,000 perpetrators being held in the Rwandan jails, sometimes for years, crammed in, very poor conditions, with no access often to health care or to food, and as I said, for a really long time. So this was a really awful situation. And sometimes the domestic court systems are completely overwhelmed with having so many people to deal with that have committed these terrible crimes. This is a picture, sorry, of a prison in Rwanda. Now, an alternative to the domestic court is an international tribunal. Now, international tribunals are not actually generally perceived as a solution to the one problem that I mentioned about the domestic court, the overwhelming of the system, because international tribunals generally only prosecute a very small number of perpetrators. But they're good for other reasons. And this, as I said, is the International Criminal Court. And it was established in the year 2002, and it's in The Hague. And it is an independent court. So while it has a really interesting relationship with the United Nations Security Council, it's actually an independent court created by a treaty. So a number of states got together, and they decided that it would be really, really beneficial to have this global court system that would deny impunity for war crimes and crimes against humanity and genocide and the crime of aggression at some point in the future. Now, one of these countries was Uganda. And Uganda was was the first country to invite the International Criminal Court to investigate international crimes committed within its borders. And this was the first investigation by the International Criminal Court, and it was the first situation in which there were indictments by the International Criminal Court. So the International Criminal Court indicted the top 5 leaders of the Lord's Resistance Army, the top 5 leaders at that time of the Lord's Resistance Army, in 2005. However, since that time, really not much has happened. Of the 5, 2 are dead and 3 are still out there. The warrants for their arrest still exist, but they're still free, and they're still committing atrocities if not in Uganda at the moment, in the DRC and other areas. So the involvement of the International Criminal Court in Uganda hasn't been particularly effective in denying impunity for these types of crimes. One of the other really interesting things about this court is that it's premised on this principle of complementarity, which means that the International Criminal Court cannot intercede into any situation unless the local government and the local court system either cannot or will not prosecute those who are deemed to be the most responsible for these atrocities. And this is part of the story behind the existence of part of Uganda's domestic criminal justice system. In 2008, Uganda decided to create what it calls the International Crimes Division of its High Court. And Uganda decided to create this so that it would be able to prosecute some of these perpetrators that were committing crimes in northern Uganda in this conflict. And it came into existence in 2008. And it's, again, been ineffective in dealing with any of the perpetrators of the conflict in northern Uganda. And this is partly because Uganda tied its own hands. In the year 2000, Uganda had enacted what it called the Amnesty Act. And the Amnesty Act guaranteed that anybody that came out of the bush that was fighting with a rebel group, who came out of the bush and who asked for amnesty, would be granted amnesty. They would be given this amnesty certificate, and they would be guaranteed that there would be no prosecution against them for any of the crimes that they might have committed. And this Amnesty Act was continuously renewed over the next number of years until this year, in fact, until 2012. So between the beginning of 2000 and now in May of 2012, when this Amnesty Act was allowed to expire, over 26,000 individuals, and I should note that this was for adult perpetrators. So people under the age of 18 didn't have to apply because they were considered completely innocent of any actions. But people over the age of 18, there were 26,000 of them who applied and were granted amnesty. So now that the Amnesty Act has expired, there's a question about whether or not the domestic court system will be allowed to prosecute any perpetrators. And it seems like they're in a bit of a problem here because very high-ranking officials, high-ranking commanders in the LRA have already been granted amnesty. So it would now just be a question of timing. If you came out of the bush after 2000 or you forgot to apply for amnesty, then maybe you're open to prosecution, but otherwise you're not. Last thing that I want to say about retributive justice, especially as it pertains to northern Uganda, is to bring back this question of local ownership, or at least local connection to the criminal justice that is being pursued for the victims. It's really important that people on the ground where the crimes took place feel a part of what's happening. And this is especially a serious consideration when the crimes are being prosecuted far away, such as in The Hague at the International Criminal Court. So here we have a picture of people in Africa. And as you can see, there's a little television screen in the middle of the picture. So all of these people are watching a court case that is happening in The Hague. So maybe this is not the best example of outreach, but at least it's an attempt. And it's really, really important to make sure that they feel at least somewhat like this is being done for them and that they're part of the process and that they have access to it. Okay, so let's look at some restorative options. Restorative justice, as I said, is less interested in judging and punishing perpetrators. And rather, it's interested in meeting the needs of victims, and of helping victims to get over what happened so that they can renew relationships and have healthy relationships within the community. One of the restorative options that is most often considered in post-atrocity contexts is something called a truth commission. And here we have a picture of one of the most famous truth commissions. This is the Truth and Reconciliation Commission in South Africa. It was created to address the abuses that occurred in South Africa during the apartheid era. So it was tasked to examine what happened between 1960s or so until 1994 when apartheid was ended. Now, although it might look a little bit like a court, it's actually very different. It's a truth-seeking official body. So it does not judge, it does not punish, rather it collects stories so that it can present a larger picture of what happened during the atrocities. So individuals are allowed to come before the Truth Commission to tell their stories. Victims would come and tell about what happened to them and how these events affected their lives. Perpetrators would come and talk about what they did, perhaps why they did it, and perhaps how these events affected their lives. And then, as I said, the Truth Commission, the commissioners here, would collect all of these stories, and they would create a report to give everybody a big picture about what happened, why it happened, and to allow victims to kind of situate their own stories within this larger picture. The philosophy behind the Truth and Reconciliation Commission, or a Truth Commission, is that it's really, really important for victims and the community at large to have knowledge about what happened and to acknowledge what happened. So to put it out there publicly, say, yeah, we understand now, and we acknowledge it, and we make it public. Now, if we bring the story back to northern Uganda, well, there's been a suggestion that a Truth and Reconciliation Commission should be used in northern Uganda to address all of the abuses that happened during the conflict. There are potentially two problems here. The one is that Uganda actually has a history of truth commissions, and not a good one. So it's actually had in its history two truth commissions, one which was wholly ineffective, and one that was more or less just a fake show, kind of. But the more recent one is the ineffective one, and it was actually created by the same government that's standing now. So Uganda has a really, really long history of horrific abuses, of different people fighting over power over the country, and different dictators treating their population really horrifically. And this started back in 1962 when Uganda got independence from the British. So when when Uganda's current president took power in 1986, and yes, this guy has been in power since 1986, which is perhaps indicative of some other problems. When he came in power in 1986, he decided to establish a truth commission to look at all of the abuses that happened to the population in Uganda since 1962 to 1986. And while the Truth Commission actually did its job and collected all these stories and made a report and made a recommendation, it was wholly ignored, both by the government and by the people of northern Uganda. And I forgot to mention that one of the important things about truth commissions is that they make recommendations as well. So they make recommendations about what should happen so that these types of crimes and these types of abuses don't happen again. And they make recommendations about what needs to happen so that the society now can get over this past history of wrongdoing and harm. So the recommendations, the reports, everything to do with this this Truth Commission in Uganda was wholly ignored. So given this kind of past with truth commissions, it's uncertain whether or not people in northern Uganda will actually receive this idea or an actual truth commission well. There's also another problem with the suggestion about using a truth commission in northern Uganda, which is that the government would likely be the one to establish this truth commission. And the Ugandan government and the Ugandan army are also perceived to have committed really awful atrocities against the population in northern Uganda. So a truth commission established by the government would be unlikely to look at any of the abuses that were actually committed by the government and by the army. So by looking at only part of the issue, it wouldn't probably be all that useful in the social healing of the people of northern Uganda, and it would be regarded probably as part of a sham. So then there's another option. Well, there are other restorative options, but we're going to look at one other in terms of its relation to northern Uganda. And that's something that in the literature is generally referred to kind of altogether broadly as traditional mechanisms of justice. And traditional mechanisms of justice are slightly different. They're premised more on restorative concepts than retributive contexts. So some communities, rather than turning to the local criminal justice system, would rather rely on their own traditional ways of dealing with antisocial behavior in their communities. And these traditional ways, as I said, are generally more restorative than retributive. This is true of the Maori in New Zealand, it's true of the First Nations here in Canada, and it's true of the Acholi in northern Uganda. Now, the Acholi in northern Uganda are not the only tribal group to be affected by this conflict, but they're the tribal group to be most affected by the conflict. So people look to them to determine what needs to be done so that the society can heal. And so the Mato Put ceremony has been suggested. And the Mato Put ceremony is a traditional, let me have a picture, is a traditional Acholi reconciliation ceremony. It was traditionally used for inter-clan murder between clans that had previously had good relationships between them. So if an individual from one clan killed an individual from another clan, and these two clans had previously gotten along really well, then something needed to be done so that these two clans could regain their good standing with each other. And so they would use this mato put ceremony. Now, preceding the reconciliation ceremony, there would be a discussion about compensation. So if you recall when I said there was retributive justice, restorative justice, and then reparative justice, well, this is an example of reparative justice. They would discuss compensation, money, or in this case cows, that would be given to the victim clan to kind of counteract or compensate for the harm that the clan had suffered. And then they would go on to this reconciliation ceremony, which would include the division of an animal, usually a goat, and they would share in a meal. And then kind of this main act of a representative from each of the clans, usually the perpetrator from the one clan and the closest victim, perhaps, of the murder person from the other clan. And they would come together and they would drink from this common bowl that you can see between them. And in this bowl is a bitter herb drink made from the oput tree in the region. And the symbolism here is that from drinking from this communal drink of this bitter herb drink, that they would be swallowing the bitterness of the conflict and promising not to engage in this bitterness or to taste this bitterness again. And at the end of this process, the two clans and all the individuals involved would be, again, reconnected in a harmonious relationship with each other. Now, the mato put, this reconciliation ceremony, has been proposed as a way to deal with returning soldiers, returning LRA soldiers that had committed abuses in northern Uganda. And it was suggested for even some of the highest ranking LRA soldiers, included Joseph Kony. Some have argued that the involvement of the International Criminal Court and the domestic criminal court in Uganda are inappropriate, and that really what should be done is that Kony and his others should come back and they should engage in a mato put ceremony, and then they can rejoin the community and everybody will deal with the harms together. At the moment, some have participated in mato put in northern Uganda, but not that many. And so then there's some more discussion about whether or not there should be widespread employment of mato put, of everybody that has returned who has committed some sort of harm against others within the community. So at this point, I hope you understand a little bit of the variety of options that are either in use in northern Uganda or that are being considered. So let's bring this discussion back to child soldiers. The goals of transitional justice are justice, peace, order, and social cohesion. And arguably, to realize these goals, there are certain necessary components of the transitional justice process that need to be met. So knowledge of what happened is necessary. Acknowledgement of what happened is necessary. And accountability, a lack of impunity for those who committed harm, is also important. Well, what about child soldiers? As agents of atrocity, are they to be held accountable or should they be treated as victims? What do they deserve? And what do their victims deserve? And what is necessary for everybody in the community to feel that justice has been met and that they can move beyond the past? Child soldiers are both victims and perpetrators. And therefore, it's really difficult to kind of gauge the true individual responsibility of any one of them. And this is especially the case, though, when they're all being whitewashed with the same non-responsible child narrative. But dealing with them appropriately, and dealing with each one appropriately, is essential, since their reintegration, their acceptance back into the society, is essential for the well-being of the future society in northern Uganda or elsewhere. However, child soldiers often have a really difficult time reintegrating. And this is true for a number of reasons. One of the reasons that child soldiers find it difficult to reintegrate is based on physical and psychological health. So coming back to the society from the bush with certain scars from their involvement in the conflict, psychological, emotional, physical scars, might make it difficult for them to be productive members of the community. Another reason that a former child soldier might find it difficult to reintegrate into the community is due to issues of resources and education. After a lengthy time in the bush fighting, these people might have missed out on important education or skills training that, again, would allow them to be productive members of the community and to allow them to find jobs that would allow them to support themselves or any family members that they need to support. But also, their integration may be hampered by the reception that they face from communities or community members. As I said, the general inclination of international law and NGOs and religious groups in northern Uganda is to depict child soldiers as non-responsible agents. So although they may be the causal agents of harm, the instruments of the harm, they're not considered morally or legally responsible. But despite this, the non-responsible child narrative might not actually be reflective of true responsibility. We need to acknowledge that the group child soldier is not a homogeneous group. Different individuals under the age of 18 committed different crimes from different motivations, held different ranks in the army. Some were leaders over others. So while they all were victims in their own right as well, there's more to the picture, and we shouldn't perhaps suggest that they're all the same. The non-responsible child narrative might also do a disservice when it doesn't resonate with the civilians on the ground. And it also shuts down communication about agency and about responsibility, conversations that perhaps should be had. Now, community members receive child soldiers with a certain amount of ambiguity. And these views are often reflective of tension that community members feel. Tension between compassion and resentment, between wanting to put the past behind them and also wanting past harms acknowledged and addressed. And also between recognizing the need to allow these young victimized perpetrators to get the help that they need to be constructive members of society, but also the mistrust and the uncertainty that some community members feel about past acts and about the future tendencies of some of these former combatants. Wrapped up in this non-responsible child narrative is also the conclusion that if the child soldier, any child soldier, is completely innocent and a victim, then any feelings of resentment or anger towards one is illegitimate. So if I'm a victim civilian and I recognize that 16, 17-year-old boy down the road is the one that hacked up my husband, well, I might feel something towards him. But I'm told that he's completely innocent and there's no way of discussing anything about this situation or to get his perspective. And I'm just told that any feelings that I may have negatively towards him are inappropriate or illegitimate. And this can add an additional level of tension to an already difficult situation. So why does the non-responsible child narrative exist in northern Uganda? Well, it's partly due to the recognition that the influence of war changes everything. So in war situations, choices are different. The actions that you commit or that you do take on different meanings and different natures. And we need to recognize this, that you cannot judge somebody in a war environment, a 17-year-old or 16-year-old or 15-year-old in a war environment in the same way that you would a 15-year-old here in Ottawa committing a very similar act, obviously. It's also partly due to the recognition of the effects of coercion. And as I'm sure you've all heard, most of these, if not all of these child soldiers have faced some sort of brutal, significant pressure to commit the types of acts that they did. And so obviously we need to recognize this as well. But it's important to note that generally, in regards to adult perpetrators, neither the influence of war nor the existence of coercion are generally regarded as full excuses for the commission of acts of atrocity. So again, this hinges only on the age. Before 18, fully innocent. After 18, well, then we'll start considering all of these other issues or factors. And another interesting point is that some of those that are considered the most responsible for the atrocities in northern Uganda, including one of the 5 who was indicted by the International Criminal Court as one of the most serious perpetrators of abuses globally, actually began as a child soldier, as an abducted child soldier. This picture here on the bottom is a picture of Dominic Ongwen. And Ongwen began, if the stories are correct, at a very young age. He was abducted at 10 or 11, and he grew up within the Lord's Resistance Army, facing the same brutal tactics and the same coercion, the same war environment, alongside Joseph Kony, in case any of you don't know what he looks like after 2012. So he grew up in this environment, rose in the ranks, and is now considered one of the most responsible individuals for horrific atrocities in northern Uganda. And as I said, indicted by the International Criminal Court. Likewise, we have Thomas Quaello. And Quaello, again, was abducted at a young age, faced the same kind of conditions, grew up in the Lord's Resistance Army, became one of the high-ranking commanders of the army, and is now considered one of the worst perpetrators of atrocities in the area. Now, Quaello was not indicted by the International Criminal Court, but he's being held by the Ugandan government, and he was going to be tried by the International Crimes Division in Uganda. However, as I said, the Amnesty Act kind of gets in there and makes trouble for these prosecutions. This was taken to the Constitutional Court in Uganda that ruled that he actually deserved amnesty like everyone else. Now you have to remember that there were a lot of other high-ranking officials of the LRA that did get amnesty. So at the moment, he's still in custody, although this ruling came out that he should get amnesty like everyone else. He's still in custody, kind of in some sort of legal limbo, and they're not sure what's going to happen to him. But even if he gets amnesty, this is a procedural question. This really has nothing, makes no statement on whether or not he's actually responsible. And he's still considered very responsible for these actions. So again, these are interesting cases. But again, there's this division. You know, where do you stop being fully innocent or mostly innocent to becoming fully responsible? And as I said, there seems to be this imaginary switch between, you know, the day before your 18th birthday and the day after your 18th birthday, where you go from being innocent victim to a possibly responsible perpetrator. Now, another reason for the non-responsible child narrative is partly due to the pressure of child rights activists who worry that any responsibility put on the shoulders of child soldiers might suggest full responsibility. So if we suggest that they're partly responsible, then this might mean, or this might be interpreted to mean, that they're fully responsible, and that no one else can possibly be responsible for that action. And this obviously doesn't seem right either. And another worry of the child's rights activists is that putting this responsibility on the shoulders of child soldiers might result in the terribly harsh treatment of juveniles. Now, if you remember, I said in the aftermath of the Rwandan genocide, there were over 100,000 people crammed into the jails in Rwanda, waiting for years for their trial dates, under really awful conditions. Well, in these jails, alongside the adults, were also people under the age of 18. And also, as I mentioned, in Guantanamo Bay, there were juveniles that were being held in a prison that was not compliant with human rights standards. So sometimes the perpetrators of really terrible harms are subjected to really awful treatment. And sometimes this is a reason, this is because there are no alternatives, maybe, as in the case in Rwanda, or maybe it's because of an aim to get revenge against really awful crimes. But either way, you can understand why there might be reason to want to protect children from that. But perhaps the solution here is not invoking the non-responsible child narrative, but rather enforcing human rights standards and the protection of juvenile defendants when juveniles actually warrant prosecution. Now, most legal domestic systems generally don't suggest that all persons under the age of 18 cannot be responsible for their actions at all. Juveniles are treated differently, but the more serious the crime, usually the more stringent the requirement that the actions and the perpetrators be addressed. Also, something to consider is that in many of the countries in which child soldiers fight, adulthood is actually younger in years than it is here in Canada and other Western nations that we may be more familiar with. Individuals take on duties and responsibilities at earlier ages. Now, this is not to suggest that we should treat children in certain countries differently than we should here. We should have the same standards, perhaps. But from the perspective of victims, having the international community suggest that perpetrators of terrible suffering cannot be responsible because they are too young at 17 or 16 or 15 is sometimes incompatible with the basic conceptions of agency inherent in the culture. Now, it's important to acknowledge that the acknowledgement of child soldiers, the ability of child soldiers to bear some responsibility, must not be equated with believing that child soldiers should bear all responsibility and that no one else could bear responsibility for the same actions. And this cannot absolve others of their responsibility for human rights abuses as well. It also does not mean that if some child soldiers can bear some responsibility, that all child soldiers should or do. It also doesn't mean that those that bear some responsibility should bear the same amount, or that do bear the same amount of responsibility. So the existence of responsibility and the level of responsibility should be determined on an individual basis. What we do need, I would argue, is a more nuanced way of looking at child soldiers that admits the possibility of responsibility and the possibility of prosecutions of persons under the age of 18 for atrocity crimes in situations in which adults can be prosecuted, providing, of course, that there are appropriate protections and safeguards, and ensuring that prosecutions consider the youthfulness of the defendant in the trial. There is no prohibition under international criminal law for the prosecution of people under the age of 18. And although there does seem to be a bit of a trend going in this direction, maybe, I would argue that I don't think it's particularly useful. Accountability, as well as knowledge and acknowledgement, is so important to the goals of transitional justice. And while Uganda and other states that have child soldiers struggle with their choices for transitional justice, there are some things to consider. 18 should not be the line in the sand. Rather, there should be a policy of gradation, similar to the ones that we have in domestic criminal justice systems, where a perpetrator of 12 would be treated very differently than a perpetrator of 16 or 17. But there's not this. Also, persons under the age of 18 must be represented in the full range of transitional justice mechanisms, including those aimed at truth-seeking and accountability. And we also need a variety of ways of dealing with different degrees of responsibility, including those that do not warrant prosecution, which would be the case in most cases of child soldiers. Most of them should not warrant prosecutions. Now, a possible option might be a type of mediation practice as a means of truth-seeking, of exploring wrongs committed and the motivations behind them, allowing for conversation, and in which perpetrators could accept responsibility and penalty when appropriate. In Uganda, perhaps using an adapted form of a traditional mechanism like the matoput might be suitable. We'll go back to a picture of matoput. The point here is that alleged former child soldiers, alleged child perpetrators, and the transitional society would likely benefit from a process of accountability that includes people under the age of 18. One that assures them and their fellow citizens that their actions and intentions and motivations have been considered. One that complies with juvenile justice standards, one that takes into account the ability of people under the age of 18 to act with agency and to then also take on constructive roles in society, and one that prioritizes reconciliation and social reconstruction. Now, of course, the conditions under which they act and the age of individuals should be considered when evaluating their actions and their responsibility. But simply disregarding all young people as lacking responsibility and agency based on their age, on this age of 18, is likely not the right approach to transitional justice in these contexts.